we will not be able to, we will not get convictions. You will know that there are a lot of cases that have gone to courts and that have been thrown out for want of such diligent prosecution that is required, and not even in a sensitive case like this. So one will expect that the prosecution or the state, as the case may be in this matter, gives the accused person, is entrenched in our laws. You know, the argument about the CCT, about the proviso
coming here, because some of the issues
in the Constitution is not tenable, because the Constitution itself in Section 36, you know, makes it mandatory. Section 36(2) makes it mandatory for every accused person to be given an opportunity to defend itself, to be aware of the charge or the case against him or her, and to be given an opportunity to respond. You know, it's rooted in our laws. It's a fundamental law in this country. So, and I sincerely wish we will help this country by doing what is right instead of playing to the climate.
Still on the matter of precedents, which you highlighted, you're talking about a case that occurred in 2011. Specifically, if you look at some of the documents making the rounds, and even in online and other publications, we're talking about the case involving Chief Bola Ahmed Tinubu, and in 2011, and also looking at what we have in some of the front pages today. CCT reasons federal government dropped charges against Orubebe. It goes back to the talk about some fundamental flaws, and they're saying that you must have been invited. Tell us more about that clause that borders on invitation that must be extended to you before such prosecution can take off. Looks like we lost our connection to our Abuja studios. We do hope that we'll have to reconnect and get him back. He's a legal practitioner and is trying to look at some other judicial precedent that has that happened set in this matter. And I'm sure this will make a lot of arguments within the judicial circle.
Well, yes, indeed, and these are some of the issues that you heard some of the views that he's highlighted, but it promises to be a very interesting one, as, of course, a lot of attention being paid to it, but not to worry. Give us a minute, we'll get that connection back and get his concluding thoughts on some of the issues that we're also trying to put across to him and get his response. We'll be right back. Welcome back. Well, we'll just go ahead and get the concluding thoughts of Donald Ayubio. You're putting a question across.
Yes, I wanted us, good to have you back again. Sorry about that, this connection there. Well, we wanted you to clarify for us the issue that has to do with invitation. Going back to 2011 and seeing what the chairman of the tribunal had said concerning the case concerning Chief Bola Ahmed Tinubu in 2011, and what we're getting to see now with Godsday Orubebe, Nigeria's former minister there, as reasons why such cases can be discharged. Tell us the provision of the law concerning invitation when matters like this occur.
Okay, thank you very much. Like I earlier said, that the CCB, the CCT Act, what Section 3 makes a proviso that that provided. May I read that to you, please, so that you get a clearer. Okay. So it said the CCB shall have the power to receive.
Go ahead.
Okay, they shall have the power to receive complaint about non-compliance with a breach of this act, and where the Bureau consider it necessary to do so, refer such complaint to the Code of Conduct Tribunal established by Section 20 of this act in accordance with the provision of Section 21 to 25 of this act, provided that where the person concerned makes a written admission of such breach or not compliance, no reference to the tribunal shall be necessary. So that is fundamental defects in the case that has been put forward by the prosecution in this case. And that is why I'm saying
a moment here, that is 3, right?
Yes.
Can you go ahead and read 4?
Hello?
Do you have, can you go ahead and read, maybe you space it more, when you get to 4, maybe there is also a proviso in 4, section 4. Did we lose him again?
Mr. Ibio, can you hear us?
It doesn't appear as though he can.
What a day.
Hello? Hello?
Can you hear us,
Hello?
Mr. Ibio?
I can hear you now. Can you hear me?
Oh, good.
Yes.
I wanted you to go ahead. You just
Okay.
read section 3.
Hold on.
You just read section 3 of the Act. We wanted you to go ahead and read section 4.
What I read to you is a proviso that fundamentally provides that the defendant that is being brought forward brought to the fore should be afforded an opportunity to be heard even before you know the matter is taken to the tribunal, and this is supposed to be done at the level of the CCB. It is the CCB that ought to have taken this written admission from the defendant before taking him or her to the CCT, to the tribunal. And that was not also done, you know, if you can recall, in the case involving Asiwaju Bola Ahmed Tinubu, and that was what led to the collapse of that case. All the case, everything put forward, you know, by the prosecution in that case collapsed on that ground, you know. And one would have expected that, taking a cue from that, this particular prosecution will also would have known that it is fundamental that you invite the defendant to make a case, you know, to be able to explain out the discrepancies you may have noticed in his asset declaration. You know, that is what is in contention here. And you know,
just a moment here. We actually wanted you to go ahead and read up section 4 of the Act. You just gave us section 3 of the Act.
yes.
Can we hear what is in section 4 of the same Act?
Hello, can you hear me?
I can hear you.
Yes, okay. So the statement of the accused person is, but the court has heard that the statement of the accused person is a fundamental document that must be brought forward, that must be put forward at every point in time, you know, before the court. In Ajani versus State, the Supreme Court heard that the statement of the accused person is the prosecution is mandated to bring it to the court. And having not done that, I think that we should look at how, you know, we can save the situation for the Nigerian public in this case.